Welcome to the learners and viewers of this program. Today we are going to discuss on two important aspects, that's called the mediation process and the product liability action. Both these aspects are covered under our Consumer Protection Act 2019 passed by the Parliament, and this subject be the School of Law, Indira Gandhi National Open University is offering a certificate course in consumer protection, and under that course the two subjects are covered. Now, first part we will take what is mediation and what is the process followed or process contemplated under the Consumer Protection Act 2019. Mediation, the very term itself defines that it is a mediation between two or more parties. That's one requirement. The required requirement is a mediation, it's a voluntary process, no force or compulsion on anybody to enter into the mediation process. And the third one is that concerned mediation for the person who is mediating between the parties concerned, he should have certain qualities and characters. What are those qualities and characters? He should have the specialist communication skills and the negotiation techniques, because the process is meant for bringing both the litigants to the case so that they can sit together in a very convenient form, in a comfortable way. They discuss and come to a consensus which is not otherwise possible through before the court of law. Now, what is the job of the mediator? The job of the mediator is to assist or facilitate the parties to a dispute to resolve their differences themselves amicably. That is very important. And what for? With the objective to find a mutually acceptable solution. But that is what the primary purpose and objective of having this mediation process. And most importantly, this process will be kept strictly confidential, and it's a confidential that apart from the litigants and the mediator, no other person will have any access to the entire process. And another important feature of this mediation is it's a participative process in nature. It's unlike the courts where the judge will be sitting, only the two advocates will be there arguing the matter. No, that type of system is not there. It's purely participatory, very congenial environment, not like the court environment where the judge will be sitting in different places, advocate will be sending other part and all. No, it will be very compact room where like a very the parties will be sitting opposite each other, and they will be say free to enter into the dialogue and all. That's what the mediation. Now, second, another feature is it is a very structured and informal negotiation. There is no binding nature on this concern. Anytime the party feels that no, the negotiation is not going to be beneficial to them, the parties themselves can withdraw from the process. Then they can go back to the consumer court. That is another thing. Then in this most important thing, first of all, why there is a process for mediation and what is the dispute that we should understand. Today the courts are taking unduly longer time to decide the matter. With the result, undue hardship is imposed on the litigants, and with they have developed sort of ventilation grievances. They agree, they are very painful between the parties and also. In the process of mediation, the parties come together. They have they can shell out ventilate their grievances. So they can express their feelings, thoughts, emotions, so that the differences and disputes are broken and a congenial atmosphere created. That is the main purpose and advantage of the mediation is concerned. And another thing is the mediator does not and is not required to impose any solution upon the litigants, but his only and one job is to create a favorable environment to enable the parties to concerned to resolve their disputes amicably. This is what the advantages of mediation is concerned. Now, another advantage of mediations are, as I said earlier, the entire process is strictly confidential. It saves times and financial and emotional cost of the resolved dispute, as I said already. Then, most importantly, in the court, what is agitated before the court of based on the rights of the person concerned. Whereas in the case of mediation, this process will be based on the interest of the parties concerned. So the right based approach to adopt the court will have back seat, and the interest based approach which is beneficial for the parties concerned, that will be followed in the mediation process. Now another important advantage of the mediation is recourse to litigation that consumes innumerable number of years and considerable amount of cost by way of expenses. But in the mediation process, if the party can agree together, come to the common consensus, this period can be minimized, the cost can also be minimized, even the agonies and also can be processed if they can come together very closely and take a decision is concerned. Now very important thing, before we we are moving to the mediation process provided under the Consumer Protection Act 2019. The law specifically provided a situation where the matter can be referred to the mediation. That situation is on the first date of hearing of the complaint, the court we will look into the complaints, and if they come to the conclusion that there is still a scope for the settlement of the disputes amicably by the parties themselves, if there is even a slightest ray of hope is visible from the complaint submitted before the consumer courts, the commissions, then the commission can refer the matter to the mediation for the mediation process. However, the parties should give their express consent for a mediation process. That means the consumer commission, whether it's a district commission or the state commission or the national commission, they on the date of first hearing ask the parties, express to them, there is a way for settling this dispute amicably between yourself. Are you ready? If the parties say we are ready, then the party should give in writing their consent for referring the matter to the mediation process. So once that process is completed, then the matter, that is the complaint filed by the parties, the entire matter will be referred to the mediation for the purpose of to begin the process. That is what. Now coming back to where the mediation cells are available or constituted, the law provided for establishment of the consumer mediation cell attached with each and every district consumer commission, state consumer commission and the national commission. So that means consumer mediation cells are available at all the district consumer commission, state commission, the national commission. Then the mediation cell should maintain records of the list of the empaneled mediators. That means each and every consumer mediation should prepare a list of panel of mediators. Then they should also maintain the list of cases handled by the consumer mediation cell, and they also maintain the record of proceedings or any other matters and all. However, coming back to the parties concerned, list of how to prepare the list of the empaneled mediators, the law provided for that. The president of the concerned is consumer commission, whether district commission or the state commission, national commission, the chairperson along with the member concerned, they will prepare a panel of mediators. Once the panel of created, then it will be given to the concerned government for notification. Then apart from that, certain nature of regulations are also provided under the law. What are the nature of regulations? First of all, the mediation council will prescribe qualification and experience required for empanelment as mediators. Then also the law, they should provide for the procedure for empanelment. There must be advertisement in the newspaper about inviting application for empanelment of mediators and all. Then the manner, after that selection is over, then the empaneled mediator should be given the training, and the nature of training, number of days of training, all those things that will be prescribed under the law. Then the fee payable to the empaneled mediators. The mediator is also paid a certain specified amount for discharging his function as the mediator. That will be prescribed the government, so accordingly he will get his fee also. The terms and conditions for empanel will also be found in the regulations, and the code of conduct of the empanel mediators, how they should behave. The code of conduct includes the maintenance the confidentiality, and if they have any interest in the subject matter, they should voluntarily come and tell that they should go out of that process if they have any interest is involved. If, for example, a mediator appointed, this may be a dispute between a company and a consumer, and a mediator is appointed, and the mediator appointed may have a share in the company. So in such case, there is an interest. The mediator, although appointed without going to records, that the mediator is having interest in the company, because by virtue of having the share. So if the mediator is allowed to mediate between the company and the consumer, it is 100% likely to go against the interest of the consumer. Therefore, in such of cases, the mediator himself should come forward and tell the commission that, look here, I am having the shares in the company, so therefore I have an interest in the company, therefore I will not be party to this mediation process. He should come and tell these things only. Now the nomination, these things are then. What are the duties? This is what the duty the mediator has to disclose before the commission. Then the procedure for mediation is very, very important. The procedure of mediation is the mediation council cell should be attached within the state district commission or the state commission, and the process of mediation should take place within the mediation within the concerned district commission, that is the district commission or the state commission or the national commission as they came in. In other words, the mediation consumer process should take place within the premises of the concerned commission. Then the next important thing is the procedure is the rights and obligations of the parties should be clearly brought to the notice of the parties, and what are the rights, what are the duties, that should be clearly told to them by the mediator. Then the mediator should also tell the parties about the usage of the trade, if any, and all those things and all. Then the circumstances giving rise to the consumer dispute, that also brought to their knowledge, or any other relevant factors as deemed necessary also. That's how things are. So these are the procedure to be followed. Then another important is how the settlement has to be reached. That is very, very important. Then based on the discussions and consensus agreed, the parties, if the consensus or agreement is reached between parties on the issues listed in the complaint, if all the consensus say reached on all the issues raised in the complaint, then that has to be reduced in writing. That listing out what are the nature of complaints made, what are the agreements reached, it should be reduced in the writing, and in the form of writing, it should be signed by both the parties to the dispute, and this signed consensus reached by the parties should be referred to the consumer district commission by the mediator, and based on that consensus report, the court will pass an order. That's the procedure number one. Then coming back, the second one is, this may be a situation, there may be several disputes raised, let us say 10 disputes have been raised, sir, 10 issues have been raised, out of which only 5 their consensus arrived, and out of the remaining 5 no consensus was arrived. In such case, that the partial consensus reached for part of the issues, and for the remaining consensus was not. What the mediator should do in such cases, the mediator should again ask the parties to reduce in writing the issues on which consensus have been reached, and also the issues on which the consensus have not been reached, and based on these two things they have to sign both the parties have to sign, and they should submit the report. Again, the mediator will submit the partial consensus report to the consumer concerned commission, which refer the matter. Then in such type of cases, what the consumer commission will do is, with regard to the matters on which the concerns have been received, these issues will be kept separately but the issues on which consensus is not reached, then those issues alone will be taken by the Consumer Commission for further proceedings for deciding the dispute by the Commission. And the third situation is where the parties fail to reach to any consensus on all the issues. That's the total failure of the mediation process. In such cases, the parties have to give it in writing again that sorry, we are not in a position to reach on any of the issues raised, so we disagree on all we are unable to reach to consensus. Then that is called the failure report. Again, the parties have to sign this reports. Then the failure report has to be sent by the mediator to the district commission. The district commission, after receiving this failure report, then they will take up all the issues for settlement by the consumer court itself. This is what in itself that we will be decided by this consent. This is all about the mediation process consent. Now we move into the another segment of today's lecture, that is the product liability action. Now we should understand what is product liability. Product liability is the responsibility cast upon the producer of the product or seller of the product or the service provider, the service provider, for making compensation for the loss or injury caused to the purchaser or the person who hired the services. That is what in a nutshell liability action means. This product liability action is applicable to every claim for compensation made by the complainant, that is the purchaser or the service hirer, for any harm or cost. Then by what manner the loss or cost be caused? It will be by defective product manufacturer or it may be by a service provided by the service provider, or it may be caused by the product sold by the product seller. So these are the way by which the loss or injury could be caused to the consumer, that is the person who purchased the goods or hired the services. Now, product liability action. Then who can bring the product liability action? That is very, very important. A product liability action to be brought by a complainant only. Complainant means a person who files a complaint against the seller or the service provider or the manufacturer. So the product liability can be brought by the complainant only. Against whom? It will be against a product manufacturer, or it may be a product service provider, or it may be a product seller. Then that is we have told about what is the harm caused and all, we have seen it. Now then what is the liability of product manufacturers? That is very, very important. A product manufacturer will be liable in a product liability action if the following conditions are fulfilled. Number one, in the situations where the product liability action will lie, in those the cases are: number one, the product contains a manufacturing defect, or the product is defective in design. Let me give an example. The product contains a manufacturing defect. Very often we have got the case also, a person had advocated purchased a vehicle, then after new branded vehicle, then after after playing it for 3 to 4 months, he noticed that the vehicle is consuming a lot of fuel than the normally required quantum by any other vehicles. So he referred the matter to the manufacturer and the dealer. Then they appointed the person concerned, and the vehicle was examined. Then it was found that there was actually a manufacturing defect in the vehicle which caused for the excessive consumption of oil by the vehicle. Therefore, the vehicle which consumes excessive oil, that can be considered as a manufacturing defect. Now, another one is situation, the product is defective in designs. Sometimes the design itself be very defective, or the design may, if same in the case of vehicle, the defective or faulty design may lead to even the loss of life of the drivers or the passengers, or to anybody also. So even if there is a defect in the design of the product, that if it causes loss or injury or to any other person, then product liability can be filed against the concerned product, say the manufacturer or the seller and all. Then the third category is if there is a deviation of manufacturing specification, generally in the case of medicines or food items and all, the specification, there are certain regulatory bodies. They prescribe the regulatory standards and specifications. So in cases where the manufacturing specification is far away from the manufacturing specifications provided the regulatory authorities, that can also be a ground for filing the product liability action. Then another way could be, another reason could be the product does not conform to the express warranty provided under the say advertisement or any other profile of the company is concerned. So these are the area by which a product liability action can be filed against the concerned manufacturer, service provider and all. And there's also one more thing is that if the product fails to contain adequate instructions of correct usage to prevent any harm or warning regarding the improper, indecent usage of the vehicle and all, that can also become a ground for filing the product liability action. Finally, a product manager will be liable in the product liability action even he proves that he was not negligent or fraudulent in making the expense warranty of your product is concerned. Now, next important thing is liability of product service provider. What is the liability of the service provider? Like say we should understand, I'm sure you will be aware, who is the service in the consumer law covers the two things. One is the goods and the services. The services, there are different types of services. Banking is a service, insurance is a service, housing is a service, medical is a hospital facilities are related to the service, telephone, even your airlines, railways, transportation, even our televisions, even these days, our mobile, all these terms are coming the services and all. The goods, we have now physical goods are perishable goods are there, non-perishable goods are there, industrial goods are there, all those things are there. So these are the type of the goods manufactured and sold is on the one side, on the another service provider and all. So with regard to liability product service provider means with regard to the service I referred about and all, and for them what are the liability and what circumstances their liability will come in. A product service provider will be liable in product liability action if the services provided him was a faulty service or imperfect service. Let us take some bank example. Let me tell you, we all are involved in the banking business transaction. We go to the ATM, you insert the money for withdrawal the money, but for whatever reason you are unable to get the required money. Some cases you just insert the card and you printed pin and all things and all. Money is not you could not get the money. At the same time, money is deducted from your account also. We all are facing every day. So here, this is what when we talk about the service provided by him was a faulty or imperfect or deficient. So it can be it can be inadequate also. Or with regard to the electricity bill. See, very often we consume less quantum of electricity, but the bill comes to a very huge amount, and very often some of the people experienced it. So improper billing of the electricity bill payment. But what the rule says, even if the billing is improper, the quantum amount is very high. What the rule says, you have to pay the amount, then you have to ask for the compensation. Suppose for the consumption is only for 200 rupees, if the bill comes for 5,000 and the rule says like 20. Therefore, in the case such type of improper, this was the deficient in services. Or phone bills, even phone bills also. You consume less number of it, but the phone they give the law. You get very large the quantum of bills against you have not used your mobile, but the bills are coming in the case of prepaid, postpaid and all. Of course, in the case of postpaid only this type of problems are concerned. Or these days this internet is very, very essential. Now there is a problem faced by this many of us during the COVID period, and our BSNL, MTNL, they are unable to provide the services, but they are dedicating every month. When you go for this 24 hours internet facility for the children, these services are very, very essential during the COVID period. But the MTNL, when we have the telephone number, the direct line, that we were not getting the internet connections. But if they were charging 800 rupees every month, so improper services, there's a deficient services likewise. So these are the examples of the deficient services in the case of service provider, but there are many other examples can be given. And again, insurance. Insurance is a claim. You say very open, at the time of taking the insurance claims, the insurance company and the agent, the promises that you will get money immediately in the case of hospital schemes and all, hospital related insurance. They said that you go to the court, we will pay you the money immediately in advance. But when at the time of need, when you go to the hospital under the insurance scheme, the patients have put undue hardship, difficulties. They under some ones of objection. No, this is not covered, that is not covered under. Again, these are the imperfect or the deficient services in the case of this medical insurance is concerned. Again, even in the case of the hospital, there was a case, a patient went to the hospital, but he died. But the hospital authorities delivered the dead body to the stranger, third person. The body, the family members claiming for the dead body, but the hospital issued the sheer negligence. They, instead of handing over the body to the real kith and kin, they handed over the body to the stranger or the third party. Certainly a deficient service on the part of the hospital authorities concerned. So these are the liability in the, definitely at the last, the family members wanted to perform the last rites. Sir, they are looking for the bodies of the died person is concerned. If the hospital is so negligent, definitely it will come under the category of deficient in the form of the service provided and all. Then the service did not issue adequate. These are the some of the say liability. Not at the these are the examples for filing a case against the service provider for all those things listed above, for claiming damages against them and all. Now the next one is about the, now what is the, so far we have discussed about the liability against the service provider. Now we are looking into liability for the product sellers. See, we should understand, product manufacturer is different, product seller is different. Manufacturing, the product manufacturer liable for any manufacturing defect. If the product manufacturer is a defect free, and if at the stage of at the time of sales or during the process of the sales, if there is any defect in the goods of and very often cases come before the court of law when the people went to the showroom, when they identified the, say, let us say television or any other thing, when they placed the order, when they paid the price, the product was perfectly all right. But during the course of the transportation, sometimes Indian roads are not that very good, not all the places and all, due to some, say, road and all, due to, say, poor transporting facilities by the prince and all, once the TV was brought home and they tried to put in, no, it did not work at all. Again, defect in the gear about the product, it has been seen. The product liability, whether it will not be against the manufacturer, but definitely is the defect on the, is the deficient on the part of the product seller is concerned. The dealer will be held liable and all. So that's what he will be. Then the dealer, a product seller who is not a product manufacturer will be liable. That what I want to bring to kind notice is, product manufacturer is different and product liability is different. Therefore, the liability of product manufacturer is different and the liability of the product seller is different. If the product seller has excess substantial control, then how to differentiate between these two, that is very important because the confusion will come in all. In case where the product seller has to exercise substantial control over the designing or the testing or the manufacturing or packaging or labeling a product that caused harm, then in such cases the product seller will be held liable and responsible. Or in cases where the seller himself has altered, has altered or modified the product for the sake of convenience, for the time of transportation and all, then modification in the product done carried out by the product seller, then also he will be held liable and responsible. And such particularly when such alteration modification was substantial factor in causing the loss or injury or damage to the concerned the product and also the purchase is concerned. That is very, very important. Then the product seller has made express warranty of the product independent of any express warranty made by the manufacturer concerned. The manufacturer given certain type of warranty, the product seller given another type of warranty, not taken to consideration or of the product manufacturer. Then in cases the product the sellers will be liable for such product liability action and all. Now, the product is sold by him, or then the identity of the product manufacturer of such product is not known. Suppose it is not a product, the liability will be fixed only in case where the damage caused is, if it is beyond doubt to identify the product manufacturer of such product, then the liability will be upon the product seller only. So those are in a nutshell about that liability of the product seller. However, there are certain exceptions to the product liability action. We will not discuss about this due to paucity of the time. However, there are two more aspects we should cover. Number one, the power to issue recall orders. In recall orders refers to the situation where the product is found defective by the regulatory authority or the government. In such, and if the continuance of product with a defective product is likely to cause loss of injury to the entire masses, all the person who purchased vehicle. In those cases, the government can pass an order with a direction to the consumer manufacturer to call back all the orders, all the products sold by them in the interest of the public's concern. There are few examples I would like to give you, that the Food Safety and Security Authority of India has initiated the recall order, passed the orders to stop production of packaged food that contained a toy in its packing. So the containment of the toy in a processed food is found injurious to the children is concerned. Therefore, the Food Safety and Security Authority of India issued a recall order. Similarly, the Hyundai Motors, they recalled for due to manufacturing defect, they recalled 16,000 vehicles. Then Mahindra and Mahindra recalled 16,908 vehicles having the manufacturing defect, and the Maruti Suzuki also recalled over 40,000 vehicles having the defects in the vehicles. So these are the actions taken by the government, ordering the manufacturers to recall the product sold already in the interest of the general public. With this, we conclude our discussion on the mediation and the product liability action. For any further information, please refer to our print material or our material available in our IGNOU portal. Thank you very much to all of you.